So if you do not have a will, the state has created one for you through statutes. And it depends on who's still alive when you die, whether that be parents, children, a living spouse. Biggest danger is what you think is going to happen usually is not what will happen. If you die without a will, for example, and you're married but have children, any solely owned asset does not automatically transfer to your spouse. In fact, like I said, if you have a spouse and children, your spouse will get the first 30,000 of those solely owned assets, and then they get half, and your children get half. Which means if you have minor children, money or assets that would otherwise be used by your spouse to care for your joint children will be tied up for the children's benefit, but your spouse does not just automatically get all those assets. And in fact, if you do not have a will, you likely do not have any kind of trust agreement. And so your children turn 18 and they get their share. So it can be pretty dangerous because, this is part of why I love estate planning is, helping educate the community on, you got to be careful with your assets. If your 18-year-old inherits a large sum of money, they're probably not going to be focused on education. They're probably going to, even though it may be an amount of money that looks like a lot, for all of us, we know that amount of money is not lasting them for their whole life. A common question I pose to clients when they are contemplating whether to have their child potentially inherit at age 18 is, with that amount of money, are they going to stop negotiating? Are they going to go buy that car, and instead of saying, well, it's a nice car, but how about I give you $5,000 less? They're just going to see the sticker price and say, I've got the money. And that money will run up pretty quickly, and there they are without the education that they probably need to make good decisions.